The Bogosity Podcast, early and ad-free. Become a subscriber at Patreon, Subscribestar, or Discord. Use the links at donate.bogosity.tv.
Welcome to the Bogosity Podcast for January 26, 2025, the podcast that understands the New York Times effect on man. This is your host, Shane Killian. Let's calcify the news of the bogus. It's the first week of Trump's second term, and Ross Ulbricht is free! Yes, on his second day in office, Trump posted to Truth Social, "I just called the mother of Ross William Ulbricht to let her know that in honor of her and the libertarian movement, which supported me so strongly, it was my pleasure to have just signed a full and unconditional pardon of her son Ross. The scum that worked to convict him were some of the same lunatics who were involved in the modern-day weaponization of government against me. He was given 2 life sentences plus 40 years. Ridiculous. Ross is now out of prison and home free, which means I need to do something. See, on social media, I said that if Trump freed Ross in his first 5 days, I'd consider that he means it when he says this second term is going to be different, and I'd judge it separately from his first. And I am a man of my word, so I'll look at Trump's presidency without chiding him for what he did before. And we'll look at what it can be, unburdened by what has been. There were other pardons, too, starting with the pardon of all the Jan 6 defendants, which really just needed to happen. There was some discussion of how to break it down. Do you do them one by one? Do you separate the violent from the nonviolent? J.D. Vance had previously said, quote, "If you committed violence that day, obviously you shouldn't be pardoned." But even the violent ones were hideously treated, kept in pre-trial detention for a long time, some even in solitary confinement. During their trial, as we covered, their basic rights were abridged, and more than one witness against them committed blatant perjury. That, along with the corrupt judges and the tainted jury pool, means that there's just no way of them getting any kind of fair trial. There was really no rehabilitating that. So, according to an advisor, Trump said, "Fuck it, release them all." I don't think I need to go over the liberal screeching that happened after this. Even a lot of Republicans criticized him. How horrible that violent people were going free. Well, maybe you should have thought of that before you made them blatantly political prosecutions and violated so many of their rights. But that wasn't even close to everything. Trump followed that up with an executive order that eliminates government requirements for low-pressure shower heads and low-flow toilets. Trump, you're starting to make me like you. Stop it. Imagine it. Toilets that work again. That can actually get everything down and keep themselves relatively sanitary. I remember those days. Note to self, buy all new toilets in the next 4 years before the next president undoes it. Also, as promised, he rolled back DEI requirements, which of course resulted in even more screeching from the left. Wow. Now they might have to get by, not by the color of their skin, but by the content of their character. How horrible. On a similar note, he removed LBJ's order on affirmative action, which likewise was met with cries of racism. Man, imagine thinking that LBJ was not a racist fuck who found a much better way to subjugate black people than Jim Crow. His great society caused more harm to black families in 10 years than Jim Crow did in 100. And as no surprise, Trump signed an executive order ending the weaponization of the federal government we've seen get really bad over the last several years. He ordered the Attorney General, quote, "to review the activities of all departments and agencies exercising civil or criminal enforcement authority of the United States, including but not limited to the DOJ, the SEC, and the FEC over the last 4 years, and identify any instances where a department's or agency's conduct appears to have been contrary to the purposes and policies of this order." He also ordered all departments to retain all documentation and to comply with the AG's orders. All right, let's move to one that's not so good. An executive order eliminating birthright citizenship, which he can't do because it's enshrined in the 14th Amendment. The technicality is in the language of the amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So Trump and company claim this doesn't apply to children of illegal immigrants because they're not subject to the jurisdiction thereof. But wait, if they're not, how can you deport them? People who aren't subject to the jurisdiction of the U.S. are people like diplomats. You can't arrest them, you can't seize them, you can't touch them, you can't even set foot in the place. It's not your jurisdiction. So either they're not subject to your jurisdiction, which means you can't deport them, or they are, in which case they're citizens. A federal judge has already issued an injunction stopping this. I'm predicting this one going all the way to the Supreme Court. Trump isn't going to back down on this one. Quick summary on a bunch of others. He withdrew from the Paris Climate Treaty, ordered all federal employees to return to full-time in-person work, ended some of Biden's actions that caused the cost of living to increase, including regulatory burdens, rent-seeking in healthcare, ending climate policies driving up the price of food and fuel, ending regulatory requirements that add 25% to the price of new homes, undoing Biden's war on energy, and ending mandates on gas-powered vehicles and the subsidy on electric vehicles. He also issued a federal hiring freeze, declared drug cartels as foreign terrorist organizations, declared a national emergency at the border, because what president doesn't love national emergencies, granted TikTok a 75-day extension on their ban, reorganized the United States Digital Service into the Department of Government Efficiency, DOGE, withdrew from the WHO, and just to be silly, I guess, renamed the Gulf of Mexico to the Gulf of America. And that's barely scratching the surface. If nothing else, no one can accuse him of being lazy. Man, these next 4 years are going to be fun. Make sure you're subscribed.
Sometimes you just have to stomp some skulls. From the mind of Mr. Dapperton, a game for the ages. In a world where a race of undead furries tries to take over the world's nuclear arsenal, one man must stop them. But which man? You choose. The Orange Overlord.
Oh, my ear!
Bernie Slanders. Debate Dominator.
My kippa's ruined!
Or Joe Sleepy.
Build me back.
And of course, Mr. Fancy Pants himself.
Forget those losers! You can get the Gold Edition and play as 4 more characters, including me, the Spooky Spaceman, along with Billionaire Brat, Professor Proof, and the easiest way to play, as Jesus himself!
7 complete different worlds, with more coming all the time. Full controller support. You can even get eaten by a worm and pooped out into a furry cathedral.
And don't forget that Gold Edition, where you can play the ultimate challenge, Devil's Doorstep.
This gory satirical adventure pulls no punches. You know you want this game. Go to links.bogosity.tv/skullstompers and play Skull Stompers now.
More news from Odysee as the legacy financial system continues to be an undue burden on them and creators, as it tends to be. They're dropping Stripe, their payment processor for monetization. In a statement they wrote, "Forcing Odysee to restrict users from using Odysee because they don't align with Stripe's policies, which are not ours, is where we draw the line. That's nonsensical. And it's also none of your business who we platform. We were working with Stripe to facilitate fiat-based creator payments. That arrangement was fine until it wasn't." So a couple of morons complained to Stripe because they didn't like what other users were posting. Quote, "Don't ask us why those creators did that. It only takes a few to spoil a good thing. This prompted Stripe to take a look into many creators on Odysee and request their demonetization if they did not align with their policy." Okay, so Stripe doesn't have to support any creators they don't want to. That's fine. It's what happened next that was a problem. Quote, "Stripe now wants to know all about our users. They want us to collect all kinds of sensitive information about you. Because Stripe doing KYC checks as the money transmitter is not enough. users should go through a prior round of arbitrary KYC checks first. That's not the worst offense, though. Stripe requests Odyssee's incorporation of third-party moderation tools to ensure that everything Odysee users post is in alignment with their own policy, even if those users aren't even using Stripe for monetization in the first place. So that's it. We're dropping Stripe. Stripe has just always been terrible for independent creators. Longtime supporters might remember Maker Support, the Patreon alternative that was shut down for reasons that were never told to us supporters, but happened after a campaign to shut down, quote, the last crowdfunding platform for white supremacists. The money we had made from that had been taken from supporters and given to Stripe, but although Stripe promised to release the funds to creators after 90 days, at least for many of us, they refused to do so. A lot of us lost money on that. Odysee says a new payment system is coming, but although they haven't released details yet, they are encouraging users to sign up for RConnect, a non-custodial wallet that lets users easily interact with Arweave apps, apparently as a part of Odysee's move from the defunct LBRY blockchain to Arweave. And incidentally, there is a fundraiser by a new LBRY foundation hoping to resurrect the old LBRY system. They make it difficult, but they can't stop it. One day they'll learn that. Or they'll go out of business entirely. For Stripe, personally, that can't happen soon enough for me. If you're on the Wi-Fi in a coffee shop or hotel, anyone on that network can get your traffic. Do you really trust all of those strangers? For that matter, do you really trust your ISP? A VPN can protect you from prying eyes, disguise your location, and even foil government censors. It's essential in this day and age, so go to vpn.bogosity.tv and you'll be taken to BoxPN. Starting at just $2.99 a month, you can get unlimited high-speed connections to VPN servers all over the world, and they don't log connections, so your privacy is assured. Traveling abroad, just VPN home, and don't worry about what those other governments are doing. Back at home, stop your ISP from traffic shaping and messing with the quality internet access you're paying good money for. You can connect from multiple machines at once, including your smartphone or tablet, and it supports all the secure standards, including OpenVPN and SSTP. Bypass censors and surveillance with your own secure VPN connection. Go to vpn.bogosity.tv. Okay, now for some great news. You know that Section 702 thing where it says that AT&T or whoever can collect your information and then the government can just get that information without a warrant? A federal court finally struck that down as unconstitutional. The case, United States v. Hasbrajami, has been embroiled in more than a decade of litigation. 4 years ago, an interlocutory appeal to the Second Circuit found that these backdoors were, quote, separate Fourth Amendment events, and instructed the district court to determine if a warrant is required. And they just determined that it is. Over the course of the trial, Congress has reauthorized Section 702 multiple times, each time blatantly ignoring overwhelming evidence that the FBI and the IC repeatedly and regularly abuse their access to these databases to do warrantless searches. Moreover, the Foreign Intelligence Surveillance Court has repeatedly denied that this violates the Fourth Amendment. The EFF said in a statement, "This decision sheds light on the government's liberal use of what is essentially a finder's keeper's rule regarding your communication data. As a legal authority, FISA Section 702 allows the intelligence community to collect a massive amount of communications data from overseas in the name of national security. But in cases where one side of that conversation is a person on U.S. soil, that data is still collected and retained in large databases searchable by federal law enforcement. Because the U.S. side of these communications is already collected and just sitting there, the government has claimed that law enforcement agencies do not need a warrant to sift through them. EFF argued for over a decade that this is unconstitutional, and now a federal court agrees with us. This might be appealed and may go all the way to the Supreme Court, but there's room for optimism there. SCOTUS was unanimous in Riley v. California, a landmark decision from 2014 that was praised as a sweeping victory for privacy rights and the privacy gift that keeps on giving. Since then, the Supreme Court has added Neil Gorsuch, who's a big privacy hawk, and Amy Coney Barrett, who's not too shabby on privacy. Kavanaugh and Jackson have also been added, but they're pretty untested on this. Still, we could expect this to be 6-3, if not 7-2, or even better. And taking a different route, the EFF said in a statement, quote, "In light of this ruling, we ask Congress to uphold its responsibility to protect civil rights and civil liberties by refusing to renew Section 702, absent a number of necessary reforms, including an official warrant requirement for querying U.S. persons' data and increased transparency. On April 15, 2026, Section 702 is set to expire. We expect any lawmaker worthy of that title to listen to what this federal court is saying and create a legislative warrant requirement so that the intelligence community does not continue to trample on the constitutionally protected rights to private communications. More immediately, the FISC should amend its rules for backdoor searches and require the FBI to seek a warrant before conducting them." Hopefully this stands. Ultimately, it'd be great if 702 were repealed entirely, but maybe we can't expect miracles. I want to tell you about the eyeglasses I've been wearing for years. As people can see on my videos, I have a very strong prescription, which makes glasses more expensive, especially when I need computer glasses, reading glasses, prescription sunglasses, and most expensively, progressive lenses for general everyday wear. To save money while still getting quality glasses, I get them from Firmoo. In fact, I just got a pair of progressives with high-index aspherical lenses and a nice pair of frames my wife loves for just over $100. It would have been $500 to get them through my eye doctor. Not only do they look good, the glasses are durable. I've worn many pairs for several years without problems. All orders come with a 30-day return policy, a 3-month warranty, and one-on-one customer service. Go to Firmoo, that's FIRMOO.Bogosity.tv anytime you need quality glasses at a low price. Once again, that's Firmoo.Bogosity.tv. And now it's time to Italianize this week's biggest Bogon emitter. And it's another one for the news media and related social media influencers for their absolute hysterics over Elon Musk at the Trump inauguration. Anyone who's seen Elon at an event knows that he comes out like a rock star and keeps the audience cheering as he works them like a pro. Yeah, the man can work an audience. So he made a gesture where he tapped his heart twice and swept out his arm to the audience, then did it again and said, "My heart goes out to you." And the liberal media went wild, sharing the still or a clip of the movement, saying it was a Hitler salute or a Roman salute when it's nothing of the kind. The gesture they post has Elon with his arm extended flat out to the side, fingers separated and curved. The Nazi salute is straightforward, up at a 45-degree angle, fingers straight and together. Really, other than the arm being extended out, it bears no similarity to a Nazi salute at all. And yet, the news media and social media went wild, sharing this and claiming it proves Elon is a Nazi. Yes, they pivoted from Elon being a Zionist to Elon being a Nazi so fast they got whiplash. No one's buying it, and yet they persist. They keep posting it and having their unthinking flunkies reposting it, and it gets constantly criticized and ratioed. And then, of course, the collective knowledge of the internet finds pictures of Kamala Harris, Barack Obama, Hillary Clinton, Elizabeth Warren, and others in a position that, if anything, more closely resembles the Hitler salute than what Elon was doing. And the liberals screeched that these pictures were taken out of context, completely missing the point. Of course they were, and so was the picture of Elon. Moreover, videos surfaced of both Tim Walz and Emmanuel Macron making the "My heart goes out to you" gesture. They tapped their heart twice and then threw their right arm out towards the audience, exactly as Elon did. Even the Anti-Defamation League came to Musk's defense, saying the gesture had not been a Nazi salute. And then none other than Benjamin Netanyahu himself posted on X, "Elon Musk is being falsely smeared. Elon is a great friend of Israel. He visited Israel after the October 7 massacre in which Hamas terrorists committed the worst atrocity against the Jewish people since the Holocaust. He has since repeatedly and forcefully supported Israel's right to defend itself against genocidal terrorists and regimes who seek to annihilate the one and only Jewish state. I thank him for this. And even after that, even people who saw Netanyahu's tweet still insisted that Elon is a Nazi who did a Roman salute. Now, come on, people. There is no way a bunch of people got this completely wrong and astoundingly bad idea at the same time so quickly. This, once again, seems like yet another coordinated attack coming from somewhere, perhaps the DNC or some other big leftist group like that, and all of the news media and all of these online influencers are taking their talking points from that to engage in gaslighting and astroturfing. If anyone can find out who they are, they can be sued into oblivion. This is defamation, plain and simple. And as the Covington kids case showed, the news media cannot hide behind freedom of the press if they're the ones that created the story to begin with. So all of that makes the news media this week's biggest Bogon emitter. Do you have children, or nieces or nephews? Are you homeschooling, or just want to counter some of the socialist indoctrination most children get in school? If so, go to Bogosity.tv/TuttleTwins, and you'll be taken to a website where you can get some great books for elementary-age children. The Tuttle Twins books are books about liberty and free market economics that include children's versions of Bastiat's The Law, Leonard Read's I, Pencil, and Hayek's The Road to Serfdom, as well as books about the Federal Reserve and how regulations protect business cronies. They'll learn about the harm caused by eminent domain, or regulations passed in the name of safety, and fundamental concepts of liberty. And as you can see from the sample pages on the website, they're all easy to read and nicely illustrated. They're just $9.99 a piece, or get a special discount as well as free bonuses when you purchase all 5. You can even buy in bulk to donate to schools and local libraries. So get the Tuttle Twins books at Bogosity.tv/TuttleTwins. And now let's over-proliferationalize this week's Idiot Extraordinaire. I guess the Biden administration just had to have one more going out the door, and this is so ridiculous they had to be smacked down by a federal judge. In particular, Mackenzie LaPointe, United States Attorney, Brian M. Boynton, Principal Deputy Assistant Attorney General, and Elizabeth J. Shapiro, Deputy Director of the DOJ under Biden. Shapiro in particular is the one who moved for this terrible motion, but it was all done at the behest of Merrick Garland and Joe Biden. We're talking about the Donald Trump classified documents case, and if you're wondering how that's at all relevant now that Trump is president and can't be prosecuted, and the case was thrown out because Jack Smith wasn't a real prosecutor in the first place, remember that there are 2 other defendants, Walt Nauta and Carlos de Oliveira. For them, the case is still ongoing. But Biden and Garland just needed to try and smear Trump one more time by releasing 2 volumes of the special counsel's report, even though Smith wasn't a special counsel at all, and releasing these smears is not only improper on the face of it, it would also prejudice the case against Nauta and de Oliveira as well. Volume 1 was shut down fairly quickly, but when it came time to stop Volume 2, Judge Eileen Cannon decided not to hold back. She ruled. In July 2024, the court dismissed the superseding indictment as to all defendants, concluding the special counsel Smith's appointment violated the Appointments Clause of the United States Constitution. Special counsel Smith appealed the court's dismissal order to the 11th Circuit. That appeal remains pending as to defendants Nauta and de Oliveira. Volume 1 concerns the election interference case in the District Court for the District of Columbia, and Volume 2 concerns this case, the so-called classified documents case, which is the subject of the pending appeal referenced above. All parties agree that Volume 2, even in its redacted form, expressly and directly concerns this criminal proceeding and should not be released publicly. The court's independent in-camera review of Volume 2 confirms this assessment. Volume 2 includes detailed and voluminous discovery information protected by the protective order entered in this case. Much of this information has not been made public in court filings, It includes interview transcripts, search warrant materials, business records, toll records, video footage, various other records obtained pursuant to grand jury subpoena, information as to which President-elect Trump has asserted the attorney-client privilege in motions in this proceeding, potential Rule 404B evidence, and other non-public information. And it's not just about the private information it contains. Quote, Special Counsel Smith provided defense counsel with a limited and accelerated opportunity to review Volume 2. Defense attorneys were required to delete prior discovery productions of material protected by the protective order in this case, and thus were unable to cross-reference the report with the underlying discovery for purposes of lodging specific and meaningful objections to the report. You can't make objections to it if you can't read it. So they were even going out of their way to keep this mostly secret from defense counsel, limiting even the time they're allowed to look at it, and now they want to release it to the public worldwide? Defense couldn't look at it to make objections beforehand, except in a very limited space and time frame, and couldn't even make copies to quote in their objections. What was it that needed to be protected from defendants in the proceedings, but is okay for everyone else to see? And there's not even any reason to release it. Quote, There has been no subpoena by Congress for review or release of Volume 2. There is no record of an official request by members of Congress for in-camera review of Volume 2 as proposed by the Department in this case. There is, however, a recent letter by some of those same members urging Attorney General Garland to release Volume 2 to the public immediately, even if doing so requires dismissal of the charges as to defendants Nada and De Oliveira. Huh? Why are they willing to let two criminals go free in exchange for releasing the report publicly? Well, we all know the answer, don't we? Because it's about Get Trump. And now they even admit it. Nada and De Oliveira never were really considered by them to be criminals. They charged them to get them to flip against Trump, remember, and as we covered, even threatened the career of Nada's attorney over it. It backfired, so they had to keep them on to save face. Clearly, they don't really consider them to be criminals at all. So corrupt. Quote, Finally, the department has identified no pending legislation on the subject or any legislative activity that could be aided, even indirectly, by dissemination of Volume 2 to the 4 specified members whom the department believes should review Volume 2 now. And this is so corrupt, so insane, that no one's even tried it before. Quote, Never before has the Department of Justice, prior to the conclusion of criminal proceedings against a defendant, and absent a litigation-specific reason as appropriate in the case itself, sought to disclose outside the department a report prepared by special counsel containing substantive and voluminous case information. Until now. According to the department, this in-camera disclosure to 4 members of Congress is necessary right now, before the conclusion of criminal proceedings, because Attorney General Garland has limited time left in his tenure as the head of the department and wishes to comply with the historical practice of all special counsel, and also because there is legislative interest in information about special counsel investigations in order to consider possible legislative reforms regarding the use of special counsels. These statements do not reflect well on the department. Oh, she's mad. They basically admitted that Garland wanted to release this last minute as a political maneuver, and she's not having it. Quote, There is no historical practice of providing special counsel reports to Congress, even on a limited basis, pending conclusion of criminal proceedings. In fact, there has not been one instance of this happening until now. During argument before this court, counsel misleadingly referenced congressional testimony by Special Counsel Weiss in 2023 as a purported example of such historical practice. But Special Counsel Weiss, after opposition by the department, ultimately agreed to testify on limited matters, repeatedly refusing to answer questions regarding ongoing litigation in order to prevent prejudice to the rights of defendants or other individuals involved in these matters. Here, there has been no subpoena from Congress to the department for Volume 2. There is no indication of pending legislative activity that could be aided by the proposed disclosure of Volume 2. Indeed, there has been no record provided of an official request by members of Congress for review of Volume 2. To the contrary, some of those same members to whom the department wishes to present Volume 2 have urged Attorney General Garland to release Volume 2 to the public immediately, even if doing so requires dismissal of the charges as to defendants Nada and De Oliveira. In short, the department offers no valid justification for the purportedly urgent desire to release to members of Congress case information in an ongoing criminal proceeding. Hey, remember when they kept using ongoing criminal proceeding as a means of stonewalling Congress's investigation into so many things the Biden administration was doing, as reported by multiple whistleblowers? Now that doesn't seem to be a concern for them. Gee. Quote, meanwhile, there are 2 individuals in this action, each with constitutional rights to a fair trial. The department has not sought leave to dismiss, and there has been no indication by any government official in this case that the department will not proceed on the superseding indictment. These defendants thus retain, as all parties agree, due process rights to a fair trial that will be imperiled by public dissemination of Volume 2. Yet the department nevertheless insists upon disclosure of Volume 2 to members of Congress now, promising that conditions of confidentiality contingent on their good faith commitment will protect against the potential for prejudice. Yeah, she knows just as much as we do how much you can rely on that. Quote, and if Volume 2 gets released in whole or in part to the public in contravention of these promises, the department assures, then defendants need not worry because this court can cure any damage caused by crafting jury instructions in the future and or dismissing the charges. Yeah, that's their answer for everything. Deny as many of the defendants' rights as you can, be as prejudicial as you want, because you can always cure it with jury instructions. Except you can't. That cure only works in very limited situations, and every judge knows it. Quote, these assertions flounder on multiple levels and do nothing to detract from the obvious. There is certainly a reasonable likelihood that review by members of Congress as proposed will result in public dissemination of all or part of Volume 2. This court lacks any means to enforce any proffered conditions of confidentiality to the extent they even exist in memorialized form. And most fundamentally, the department has offered no valid reason to engage in this gamble with the defendant's rights. The bare wishes of one attorney general with limited time in office to comply with a non-existent historical practice of releasing special counsel reports in dependency of criminal proceedings is not a valid reason. Even less clear is why the department would defend this position notwithstanding its own justice manual, which expressly directs against disclosing substantive case information in a criminal case. Man, the judge is seething. And she even went so far as to remind them of the model rules of professional conduct from the American Bar Association, which says, quote, a prosecutor has the responsibility of a minister of justice and not simply that of an advocate. She enjoined them from releasing Volume 2, ruling, quote, releasing Volume 2 to Congress without any enforcement mechanism to prevent public dissemination presents a substantial and unacceptable risk of prejudice to defendants. Prosecutors play a special role in our criminal justice system and are entrusted and expected to do justice. The Department of Justice's position on defendants' emergency motion as to Volume 2 has not been faithful to that obligation. Dang! You know, I'm going to miss these smackdowns as it seems like only the Biden administration has been corrupt enough to really warrant them. But then, we've seen terrible behavior in the AI cases too, so we'll look at those and keep an eye out for any others. But for now, that gives Joe Biden, Merrick Garland, and the outgoing DOJ one last Idiot Extraordinaire! Well, that wraps up this What a Doge Does When the Doge Does His Duty to a Duke edition of the Bogosity podcast. I hope you enjoyed it. If you did, please go to donate.bogosity.tv for several ways to support and discord.bogosity.tv to join the discussion. Subscribe at the Discord or at Patreon or Subscribestar, and you can listen early and ad-free. Thank you for listening. Until next time, here's a quote from Christopher Darden. People need to understand that prosecutors are lawyers, and like my grandmama once told me, a law degree is a license to lie. The Bogosity podcast is licensed under Creative Commons Attribution, Non-Commercial, No Derivatives 4.0 International License.
Bogosity.